The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, the 27th of April, 2016, are currently trading with gold at $1,244.98 an ounce, silver $17.20 an ounce, Texas crude $42.64 a barrel, and Bitcoin is currently at about 457 U.S. currency. Today in history, the year 1909, the Sultan of Turkey, Abdul Hamid II, is overthrown by the Sultan's military counter-coup, which was in response to the Young Turks' coup. His brother Rashad Effendi was then proclaimed as Sultan Mehmed V, the fall of Abdul Hamid II. Today in history. In recent news, Dennis Hastert, former House Speaker, was sentenced to 15 months in prison and ordered to pay $250,000 today and 2 years of supervised release once he finished his prison term. The fine is for a victim's hush money case, which was uncovered by the FBI, where he was accused of sexually abusing young boys as a teacher in Illinois. Hastert did admit to Judge Thomas M. Durkin in open court that he abused at least one child. The primary accuser in a sexual abuse case, who had received $1.7 million from Hastert, has also sued Hastert for the remaining $1.8 million he was promised. The president of Venezuela, Nicolas Maduro, announced on his regular presidential broadcast that in a desperate attempt to save electricity, the public sector or government employees, who make up a third of the country's workforce, will work Monday and Tuesday and have the rest of the week off. This 5-day weekend is being implemented in order to save as much electricity as possible. The shortage has resulted from a drought the country has been going through since Venezuela's electricity primarily comes from hydroelectric plants. They're banking on the rainy season, which is expected shortly, to save the country's electric shortage. Forced blackouts lasting 4 hours at the minimum have been imposed across much of the country, putting the country's scarce food supplies at restaurants and markets at risk of spoiling. For more than 12 hours after the declaration, rioters, as could be expected, went on a spree against businesses and even attacked the headquarters of the government's power company, Corpo Elec. If significant rainfall does not arrive within a few weeks, much of Venezuela will be at risk of a near total blackout. Venezuela's economy is projected to shrink 8% this year, with inflation running at a whopping 720%, according to the International Monetary Fund. Though the effects of socialism on people are not funny, I can't help but ask what socialists used for light before they used candles. Apparently it was electricity. This was your lowdown for April 27, 2016.
You gonna do? Yeah. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? When you were 8 and you had bad traits, you go to school and learn the golden rule. So why are you acting like a bloody fool? If you get hot, then you must get cool. Bad boys, what you gonna do? Or what you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? You chuck it on that one, you chuck it on this one, you chuck it on your mother and you chuck it on your father, you chuck it on your brother and you chuck it on your sister.
Okay, howdy, this is Randy Feltman, Jetpack Boulevard Radio. On this Saturday, on this Friday, the 29th day of April 2016. I'm down here in Austin tonight. Vet may not be with us. She's probably traveling to Austin as we speak. And she'll be down here tomorrow. We're here for a very special occasion in Austin. It is important that every year we celebrate Eeyore's birthday. One of the most important celebrations of the year, and you can only see it in Austin, Texas, where everybody's weird. Anyway, okay, we'll have our phone lines all open, and if I can hit the right button, I get them open. The phones are going to be open all night. I'm going to start out talking about Thursday, the 21st, Thursday last week. This is something I've been working on and getting prepared for actually 30 years or so. I finally got the door open to the grand jury, and I filed against my district judge. First-degree felony aggravated assault for assaulting me with a armed bailiff. It is as technical a complaint as I could make, and I only made it so that I could use the district judge as a way to force the Texas Rangers to change their protocols. Now, the district judge was very accommodating in this. If I filed a really egregious accusation against a public official, it would dilute the effect of the complaint, as the purpose of the complaint is not to put focus on criminal wrongdoing by anyone other than the Texas Ranger. We got new. Well, I may not spend too much time on this. I've got 3 callers already. If I have time later, I'll talk about why I filed first-degree felony aggravated assault charges against my local district judge, criminal conspiracy against a Texas Ranger and the director of the Department of Public Safety. They're before the grand jury now, and they have to wait until next month to find out if they get indicted or not. So that one's cooking. I have 3 callers, so I'm going to go ahead and start out with callers. Our first caller on the board is Joseph in New York. Hello, Joseph.
I'm on the radio, but hello.
Hello. What do you have for us tonight?
Well, I have a real basic question for you. It has to do with I got a traffic court issue going on, and the deputy DA filed an affirmation in opposition of a motion to dismiss. Now, she refers to herself as a deponent, and I'm thinking, this is a violation of Frizzy versus Pagliaro.
Wait a minute. Deponent?
Yes.
Explain to me who is being deposed.
Herself. Deponent is an attorney licensed to practice law in the state of New York and is the assistant district attorney representing the people in the Village of Ilion Justice Court. That's what she said.
Let me make sure I'm hearing the word right. Am I hearing opponent or deponent?
DEPONENT.
Okay, that means someone who's being deposed. So are you deposing the prosecuting attorney?
No, she deposed herself.
Well,
does that make any sense?
Okay, wait a minute. That'll take some explanation. She deposed herself.
Yeah.
Do you have a transcript or a video of the deposition?
Yes, I have I have this written thing, an affirmation in opposition to motion to dismiss, and this is what she's written.
Oh, wait a minute. You're in New York State. Information in opposition to motion to dismiss. These are odd terms.
Right.
Generally, there would be just a response to a motion to dismiss.
Correct.
Okay, if I have me a notepad, I'm not in my office. I'm in Austin at the moment. So
this is a total violation of Frizzy versus Pagliaro. Not only that, I've got her. I accused the judge of judicial misconduct because I demanded a copy of the accusatory instrument.
Okay, wait a minute. Maybe part of the problem is you kind of started in the middle of your case. Give us a brief synopsis of where you're at so we can kind of get focused.
Well, this was actually the beginning. I went to my village court to be arraigned.
No, wait a minute. That's the beginning of today. Okay, you got a traffic citation?
Yes, 5 of them.
Okay, that's pretty good information for us to understand, so we can kind of figure out where you're at. Will you kind of explain the 5 citations? Are they all the same incident? Did you get them all at once or over a period of time?
Correct. Yeah.
No. That was a question. One or the other. All at once or over a period of time?
All at once.
All at once. Okay. Tell us what happened. Briefly.
Pulled over for. I got hit with a plate reader. I hadn't had a chance to turn in my plates. I tried to turn in my license and registration, and the woman at DMV refused. She said, "You can't just turn them in." And so I said, "Okay, well, I'll have to go over your head." And in the meantime, I got hit with a plate reader. So I got, unlicensed, unregistered, uninsured, uninspected, all that. And, so I was, I went to my arraignment, and I asked for a copy of the accusatory instrument. And
hold on. This brings I'll arraignment. I'll test that later. Go ahead. I'm sorry.
Well, he declared that it was an arraignment.
Okay. The reason I stopped you is in Texas, the Code of Criminal Procedure says that an arraignment is a hearing in a matter punishable by imprisonment for the purpose of determining the identity of the accused and taking a plea. Before you can go to an arraignment, if you signed the citation and agreed to appear in court, if you read the citation, it most likely says that you agreed to appear before some magistrate. If the citation doesn't say it, almost certainly the state law will say it.
Right. Yeah, I signed nothing.
Okay, so you didn't see a magistrate. Okay, go ahead.
Well, so at any rate, the magistrate entered a plea against my protests. I demanded a copy of the accusatory instrument that the statute requires that must be given to me upon my arraignment. He told me,
okay, say that again. You demanded a copy of the two-party instrument?
No, of the accusatory instrument.
Oh, okay, accusatory instrument. Okay.
All I had were the five naked complaints. I wanted to challenge nature and cause. He told me the prosecutor isn't here. You can't do that. And I said, well, that's too bad that she isn't here to attend her case. I demand a copy of the accusatory instrument that the law requires you hand me right now. And he said, the tickets are sufficient. And I said, statutes disagree with that, and the case law disagrees with that. And so I moved to dismiss, for the estoppel, had occurred, and for judicial misconduct, and for the prosecutor.
Okay. If the statute required him at this initial hearing to provide you with nature and cause, and he failed to, that's a due process violation.
Exactly. So I hit him with a call rito and he recused himself. So it got transferred to town court. All right. And while it was being transferred, I got this affirmation in opposition and motion to dismiss.
Okay. And, hold on. Did you file a motion to dismiss, a written motion, or is he referring to the verbal motion in court?
No, it was written.
Okay. When did you file that?
About 3 days after the arraignment.
Okay.
That would have been 2 months ago.
Okay, that's good. I needed kind of the order of how that occurred.
Right.
Okay.
So, the first part of it, I don't have a problem with. She just basically contests. Well, I'm glad you finally stopped. You never do. I know you're busy. I don't want to. Well, I'm on the radio, but this is cool. I'm glad you stopped by. So stop by. I'm sorry. Good friend of mine. I hardly ever see him.
Tell him you're on the air at the moment.
I just did.
Okay. Okay.
So at any rate, the first part of her affirmation, I don't have a problem with. Basically, she just states a bunch of statutory law that she's relying upon to contest my motion. I don't have a problem because it's all irrelevant. But then in the second part, she defends the judge. I attacked the judge specifically, and she's basically defending the judge. It's nothing to do with her. It's my attack on the judge is between the judge and myself.
Okay, so
the reason go ahead.
Okay, so yeah, but if she's defending the judge and the judge is not, is the behavior of the judge relevant to the motion to dismiss?
Yes. Matter of fact, if you want, I can bring it up.
Okay, then.
Motion to dismiss was.
Okay, it's within the scope of the prosecuting attorney to defend the behavior of the judge.
Is it?
In an attempt to show cause as to why the case should not be dismissed. So yeah, that's within her scope.
Oh, okay, I didn't realize that.
Yeah, the judge is not a lawyer.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Okay, Randy Kelton, Vet Pack, Wheel of Our Radio, kind of fell off the cliff there. I was asking questions, taking notes, and missed my outro. Okay, where were we, Joseph, when we fell off the cliff?
Well, yeah, we were talking about my attack on the judge. I just brought it up. This is what I put in my motion to dismiss concerning the judge's actions. I was called to the podium by Stephen J. Knight. I didn't refer to him to the Honorable. To answer the 5 charges. I was asked, how do I plead? I answered, I'm reserving my plea until I see proper notice. The prosecution's notice is inadequate and incomplete to make a reasonably informed, intelligent, and voluntary plea order confer jurisdiction upon this court. The magistrate ruled that the tickets were enough notice. I attempted to object and rebut. Mr. Knipe declared that he wasn't going to allow me to read anything into the record and stated that he was going to enter a plea of not guilty against my protestations. I restated that I was reserving my plea. He ruled that this is a court of law and stated that he was going to enter the plea of not guilty and refused to allow me to make any dilatory pleas or preemptive challenges or to ask any preliminary questions. I asked for a copy of the accusatory instrument, and he said he didn't have one and the tickets were sufficient. He declared that any further communication would be ex parte communication and forbid me from further responding to the charges.
Wait a minute. The judge ordered you to a hearing, and he ordered you to an ex parte hearing? How does that work?
I don't know. It's ridiculous.
Yeah. What I'm doing, that was kind of a rhetorical question. The question's really for the judge. Judge, how does that work?
Yeah.
You order me to appear at an arraignment hearing, and the state's not represented? So are you the prosecutor now?
Oh, exactly. That was what I said. The magistrate rescheduled my arraignment sua sponte because, I moved to, dismiss, and he was like, forget that. And I said, well, there's no accusatory instrument, no affidavit, no fact witness, no complainant. There were no facts of a jurisdictional nature that would confer jurisdiction upon the court. The village court lacks subject matter jurisdiction. My right to due process and equal treatment of the law have been violated. And further down, I complained that the judge, joined the court in the prosecution's cause of action as a moving party to the litigation. What does he think he's doing?
Exactly.
And, now I made that motion, and the new judge, it went from village court to town court. This judge upheld the DA's affirmation in opposition to my motion, and I'm like, really? So right now, I had a very basic question. How do I properly attack this? Do I attack this with a motion to quash? Because I'm learning, but I'm still new at this.
No. Once you have the ruling, okay. Let me back up. This is New York, so I'm not exactly sure of the particulars of traffic court. Are you in front of a municipal court or a justice court?
It's a justice court.
Okay, so it's in the county.
It's town court.
Okay, hold on. Were you given the citation by a county sheriff or a municipal police officer?
Super.
Say that again. Okay, hold on just a second. If you speak while I'm talking, there's a suppressor on the system. It will push your voice down below mine and we won't hear it. Okay, so municipal court or a county or a generally here we have municipal court if it's in a city. If it's outside in the county, then it'll go to a justice of the peace.
Well, from my understanding, this is what they call a town justice court.
Okay, so it is within a municipal or within city jurisdiction. It's not county jurisdiction.
This is correct.
Okay, so are municipal courts in New York courts of record?
No.
Okay, so an appeal from the municipal court is appeal de novo.
Correct. No.
Okay, let me explain to those who don't understand what we're talking about here. A court that is not a court of record, these are considered inferior courts because they can be manned by non-lawyers. A justice of the peace or a municipal court judge does not necessarily have to be a lawyer. So they're considered inferior courts. An appeal from an inferior court can be trial de novo. Trial de novo means as if the original trial didn't happen. However, it only means that for the purpose of perfecting your appeal. What the courts want you to think is that it actually is as if the original trial didn't happen, and that is not the case. You don't have to appeal on writ of error. If this were a court of record, And in Texas, we have both. We have some courts that are not courts of record, but certain cities can register themselves as a court of record, in which case the judge has to be a lawyer. And from that, you don't get a appeal de novo. You have to appeal based on writ of error. So in Joseph's case, it's an inferior court, so he can appeal without having to claim error. That's what trial de novo means. It doesn't mean they're shielded from the garbage they pulled in the original court. And that's what they'll try to claim. So they tend to do anything they want to in the original court because they presume that an appeal will result in trial de novo. And we go to the Court of Appeals and say, no, it does not affect trial de novo as concerns the improprieties on part of the original court. Am I making sense in that, Joseph?
Yes, you are.
Okay, that means that in the next court you can go after these guys for your due process was denied. Just because it's trial de novo doesn't mean your due process got undenied somehow.
Right.
And due process violation is harm per se. You don't have to show harm. It's a harm as a matter of law.
Mm-hmm.
Okay, now we're at the point where you filed a motion to dismiss. Counsel filed an opposition. Judge ruled in counsel's favor. Not much more to do until you get to the Court of Appeal, to the next step, the appeals court. Because he's made a final ruling on that issue. I don't know if in these municipal courts in New York, do they allow for a motion for reconsideration?
Yes.
Oh, good. Then have you written up a findings of fact and conclusions at law?
Yes.
Okay. Have you filed a motion for reconsideration, including the findings of fact? And for those who don't know about this, a judge has a duty to determine the facts in accordance with the rules of evidence, then apply the law as it comes to him to the facts in the case. If the judge rules against you, then you have a right to appeal. But if you don't know what law the judge applied to what facts, you have no way to know how to appeal. So you ask the judge for findings of fact and conclusions at law. And the standard way of doing that is you offer findings of fact and conclusions of law. You say, these are the fact, and these are the laws that apply to those facts, and this is the conclusion you should have came to. And you ask the judge to accept your findings of fact and conclusions of law or prepare and present his own so that you know how to appeal the issue. Okay, that's my story, and I'm sticking to it. Okay.
Well, that's fantastic. I'll do that very thing. Okay. Yeah. Other than that, both of these judges are cowboys. I was up against this judge in Herkimer Village Court. He was the judge of both.
Okay. Hang on. We're about to go to another break. Randy Kelton, Vet Pack, Rule of Our Radio. Our call-in number, 512-646-1984. Call boards are full at the moment. As soon as someone drops off, it'll open up a line. We can only hold 4 at once. So we'll be taking your calls all night. We'll be right.
This tropical fruit does wonders for your heart, skin, and hair. Plus, it kills harmful bacteria and promotes oral hygiene. I'm Dr. Catherine Albrecht, and in a moment, I'll let you know what that healthy something is.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Coconut oil has long gotten a bad rap. Although partially hydrogenated coconut oil is unhealthy, virgin coconut oil can do wonders for your looks and your health. Let's start with the antioxidant effects. Much like vitamin E, coconut oil helps exfoliate and repair damaged skin. It stimulates thyroid function and converts cholesterol into anti-aging steroids, lowering the risk of cancer and heart disease. Coconut oil also promotes weight loss. By boosting your metabolism, it makes you feel full longer. Finally, it's a natural antibiotic that can help prevent tooth decay. So let's all go nuts for coconut. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
You're listening to the Logos Radio Network at logosradionetwork.com. Yeah, I got a warrant, and I'm going to serve them to the government, them, prosecute them. Okay. Outside. Citizens are rich.
Okay, we are back. Randy Kelton, Blue Bell Radio, and we're talking to Joseph in New York. Okay, Joseph, they've already ruled on that. So, and have you sent in the motion for reconsideration?
Well, I haven't. I haven't submitted it yet. There were some other motions and notices that I wanted to get before him first. Now, this new judge did the same thing that the first judge did, and he now the first judge tried to apply a case number to the case without an accusatory instrument, and I protested. I said there can't be a case number without a case, and there can't be a case without an accusatory instrument. So he didn't. But this new judge did. He just said, well, there's a case number anyway. So I'm challenged. I'm just, on all my paperwork, I'm just putting cause number. But there's no case. But he entered a plea of not guilty against, my protestations. And when, I challenged him, and, I told him, without the proper understanding of the cause, and without the nature being anything more than hearsay, I can't plead. And so he said, well, if you keep this up, I'm gonna order a competency hearing.
Wow, wonderful.
I said, you just go right ahead, see what happens to you. And then he told me, if you keep making trouble, he said, I'm just gonna throw you in jail until your next hearing.
Hold on. What are the statutes in New York for witness tampering and obstruction?
I don't know. I'd have to read them up and read them.
Pull them out. In Texas, it's 3605, 3606. Mm-hmm. Witness tampering is a felony in Texas. It probably is in New York. He just threatened you with a competency hearing because you were actively adjudicating your case and pleading your rights. That's witness tampering.
Yeah.
And that should certainly get the accusation. Okay, let's talk about the New York grand jury. As I understand, a few years ago, the New York legislature reworked the grand juries in New York in order to strengthen them. And you have a good grand jury system. Now, here's what I want you to look for. What does New York law say are the duties of the grand jury? The reason I ask the question this way is in Texas it says, the grand jury shall investigate into all crimes subject to indictment that come to their knowledge by way of any member of the grand jury, by way of the prosecuting attorney, or any credible person. I believe, if I remember right, New York says the grand jury shall investigate into all crimes that come to all crimes subject to indictment that come to their knowledge by whatever means.
Yes, I believe it does too.
Okay, if that's what it says, then that establishes your statutory right to give notice to a grand jury. It does not establish your right to present to a grand jury. Most states will have a statute that only authorizes the prosecuting attorney to present to the grand jury. And where there is a specific authorization, what is not included in the authorization is excluded. However, you have no interest in presenting to the grand jury. You have a duty to give notice. Now, in Texas, we have a statute that makes it a felony if you have knowledge of makes it a crime, not a felony. Makes it a crime if you have knowledge of a felony and don't report it. But ours is specific in that a felony involving bodily injury. You might look at New York. If we're not statutorily required to report crime, we are at least civilly, in a civil society, we have a duty to report crime. And when you report crime as the master of the servants. By that I mean, I just gave a verified criminal affidavit to a Texas Ranger accusing a public official of committing a crime. And my position is, what I gave you is not something that's subject to your discretion. I am the master. I gave you notice by verified affidavit that a crime has been committed. You have no power to challenge that. You must do what the law requires you to do. And in Texas, it says that under 2.13 duties of peace officers, they must give notice to some magistrate of all crimes committed in the county. So when you give them the verified criminal affidavit, they have officially been given notice by their superior. Now, they're going to want to hide it, do something else with it. And that's okay, because then when they don't act on it, you get to charge the officer with tampering and shielding. Does this sound like fun, Joseph?
Oh, yeah. Now, you're talking about the DA here, right?
Yeah.
I'd be handing the notice to the DA, and he'd be...
No, I'm talking about the judge that threatened you.
Oh, so I'm going to hand the notice to the judge.
The judge threatened you in court. That's witness tampering.
That's correct, yes.
I don't care who he is. You are the master. He is the servant. It is his duty to determine the facts in accordance with the rules of evidence and apply the law as it comes to him to the facts in the case. Whether he likes the facts he hears or not, you don't care. If he attempts to prevent you from exercising a right by denying you access to the court, and that's what he did in this process. He denied you in your right to petition the court for redress of grievance and threatened you with retaliation if you continue to petition the court for redress of grievance.
Yeah, two different forms.
That's probably a felony. I'm almost certain it is in Texas. Witness tampering is considered a really, really big deal.
Well, I also asked him for a record of the hearing. Normally the courts will give you a little CD that you have to give to transcriptionist, and he said, "No, I'm not giving you anything." And
did you record it?
Did I record asking for it?
No. Did you record the hearing?
I set that up to be done, and the guy that was supposed to be there with the recorder didn't show up on time because he thought, I'm normally called last because they know I always fight.
Okay, well, I have recorders.
I got called up right away.
Okay, you need to fix that. I have a really nice pen drive, and I have a press pass that I wear, and it's got a little pouch on it. I always keep the pen drive in the pouch. I have a couple of really nice pens. I've got a name tag that's got my picture on it, and it says press on it. I've got a key for my car, and it hangs on my press pass. I'm bristling with recording devices, and that flash drive cost me $7, and that thing is good. I just recorded a Court of Appeals hearing that I couldn't hear a word they were saying, but I can hear it on the tape. So I suggest you get a couple of those. And the coolest way to handle it, and this might have been you, are you the one that had 2 recordings for the police and you recorded them trying to erase the first one?
No, it wasn't me.
Okay, we had somebody from New York, and I suggested to them take 2 recording devices and let them see one. And when they tell you to turn it off, they never think that you might have another one. Hang on, Randy Kelton, Boulevard Radio. Our call-in number, 512-646-1984. We'll be right back.
Easy.
Okay, we are back. Randy Kelton, Vets Pack, Boulevard Radio, and we're talking to Joseph in New York. And Joseph, you were a great caller to start out the show with. And I do want to explain something. I'm not trying to be pedantic in some of my explanations of things you obviously already know. You're obviously ahead of the game. The whole purpose of what I'm doing is trying to bring other people up to your speed.
Well, so what's happened with me is I've learned a lot about some things, but I'm still really amateur at others. So I don't feel, I'm never going to feel that you're pedantic. I'm still learning.
Okay. Then there's a place I want to go. When I first started the show, I told about filing first-degree felony aggravated assault charges against my local district judge. What I didn't explain is why I did that. I did that because I got him upset at me. He threatened to have me arrested, ordered the bailiff over to arrest me. The bailiff put his hand on my arm. And he threatened to have me arrested because I demanded that he call the grand jury he had just impaneled back into the court, disband that grand jury, reconvene the panel so that I can exercise my statutory right under 19.27 to challenge the grand jury panel. And he refused. Said I'd have to use the right procedure, and I told him that the statute does not prescribe a procedure, and since you are the district judge, it is your duty to ensure my rights. You must determine the procedure. Well, Mr. Kelton, you're just going to have to figure out what that procedure is. I said, well, we'll see what Travis County has to say about that. You can file in the seat of government from any county. You can file to Travis County. And he said, are you threatening me? Mr. Kelton, you just threatened me. Mr. Bailiff, arrest this man. The bailiff come over and put his hand on my arm. And I looked down and said, Mr. Bailiff, I see you wearing a pistol. Yes, Mr. Kelton, I am. Tell me, Mr. Bailiff, is that pistol loaded? Yes, it is. And the judge said, Mr. Bailiff, you can back off. He got it. I had done this to him before. He hated me. He ran in the courtroom once when I was talking to the bailiff and said, Mr. Kelton, you're creating a disturbance. You get out of this courthouse or I'll have you arrested. I said, oh, gee whiz, Judge, I'm sorry. And I reached in my pocket and jerked out this little digital recorder. I didn't have this turned on. Click. I stuck it right in his face. Will you say that again? Well, I was talking to the bailiff because the high sheriff of the county refused to dispatch an officer to arrest the district attorney and said I would have to make my complaint to the bailiff because he was the chief security officer. So I'm making a complaint to the bailiff at the direction of the high sheriff of the county to ask him to arrest the district attorney, and the judge comes in and threatens me in order to interrupt my access to a public building. 2206 Texas Penal Code calls that a terroristic threat. And I filed it against him with the Attorney General. Oh, that was so much fun. And that's when he stopped sending me Christmas cards. So he was already pretty upset at me. And then when he did this one, because he knew from the last time that I would sting him. And so he ordered the bailiff to back down. Sorry, Bubba. That bell's already been rung. Now, I don't know what he feels about that loaded pistol, but I have spent some time on the sharp end of those things, and I take them deadly serious. And so does the Texas legislature. They said if you commit simple assault as defined by 2201 Texas Penal Code, which is a Class C misdemeanor, and you are prominently displaying a deadly weapon, that's a felony of the second degree. Unless you are a public official acting under the color of an official capacity, color meaning pretense, then that is a felony of the first degree. Our legislators intended that when that officer straps on that pistol, that he straps on an extremely serious responsibility. They were not kidding. But the bailiff didn't assault me. The judge did.
The judge did.
The bailiff was the deadly weapon he assaulted me with, and that's what I filed. So you were close to the same thing.
Yeah.
You were threatened by the judge in the courtroom for having the audacity to vigorously adjudicate your case, when the Supreme has been very clear. Rights belong to the belligerent litigant. If you don't claim them, you waive them. So he threatened you with retaliation for exercising your statutory rights. Explain that to a grand jury, Bubba. Okay, now let's go to grand jury. In New York, what is the jurisdiction of a grand jury? Now let me back up and explain why I ask that way. In Texas, a district judge impanels a grand jury. And that district judge has a venue restriction. Now, he is a statewide judge. And in the old days, when there weren't a lot of judges rode the circuit. So they had jurisdiction all over the state. But once we got more people and more judges, the legislature restricted each judge to a venue. However, I find no similar venue restriction applying to a grand jury. A grand jury, while it's impaneled in a county, is a statewide office. I find nothing that restricts a grand jury from hearing any complaint from anywhere in the county. I find nothing that authorizes anyone to interfere with the grand jury. As a matter of fact, Scalia in Montgomery v. U.S. stated concerning grand juries that while a district judge consecrates a grand jury, once the grand jury is impaneled, it is essentially a fourth branch of government as answering to no one, and that is the way it is in New York.
Mm-hmm.
So see if there's anything restricting the venue of a grand jury. And what that means is you can take your complaint to any grand jury in the state. As a matter of fact, you can take it to every grand jury in the state. A no bill is not a bar to a subsequent notice.
There was one question I had concerning that we talked about earlier. Who is the proper public official that I would take this notice to the grand jury to? Now, if there's going to be a grand jury impaneled, I'm going to be my case is going to be transferred to a court of record.
Okay, that is a perfect question, because a prosecutor is going to tell you it's the prosecutor. And when I look in the law, I don't find that. What I find is that a prosecuting attorney, when he's made known that a crime's been committed, that if the allegation is a misdemeanor, then he's to submit the complaint to the clerk of the county court. If the complaint is a felony, he is to submit it to the grand jury. He is to reduce the complaint to an information and submit it to the grand jury, and submit the complaint to some magistrate. In every state I've looked at, all complaints are directed to some magistrate. Nothing directs a complaint to a police officer. Nothing directs a complaint to a prosecuting attorney. But realizing that prosecuting attorneys are often given notice of crime, they're required, when they're given notice, to send the complaint to a magistrate, reduce the complaint to an information, and submit that to the grand jury. A magistrate, when he holds an examining trial, is commanded by 17.30 Texas Code of Criminal Procedure to seal all the documents had in the hearing, cause his name to be written across the seal of the envelope, and forward it to the clerk of the court of jurisdiction. And this is very reasonable, because a magistrate does not necessarily have to be a lawyer. So they want to preserve the evidence on which the determination of probable cause was made, so that the magistrate is to seal all the documents, send it to the clerk of the court of jurisdiction. And in Texas, it says, if it's a felony, the clerk shall keep all those papers safe and deliver them up to the next grand jury. So the prosecutor stands aside from the process. And this is because of the archaic law. Before prosecutors in 1865, I think it was, they created prosecutors. 63, 4, 5, somewhere around there. Before that, there were no state prosecutors. You'd hire a lawyer to prosecute. So there wasn't a prosecutor in the mix. The complaint goes to the magistrate. The magistrate makes a determination of probable cause, sends it to the court of jurisdiction. There's no prosecutor involved. And I'm going to bet that's the way the law still reads in New York. The prosecutor got put in later. So there's nothing that directs a complaint to him, so screw him. And if the...
Well, I would present it then to the presiding judge?
No, you put it in an envelope and mail it to the district attorney's address, addressed to the foreman of the grand jury.
Oh, okay.
And then put a cover letter in the envelope asking the foreman to initial this document and return it to me. This is merely verification that you actually received this document, because we have problems with prosecuting attorneys secreting complaints from grand juries. So please initial this and return it to me in the included stamped self-addressed envelope. When you don't receive that back within a reasonable time, say 7 to 10 days, you have reasonable probable cause to believe that the prosecuting attorney tampered with the U.S. mail and tampered with the government document by secreting it from the office it was directed to. Then you file another one with the foreman, accusing the prosecuting attorney of secreting your...
It's all according to the will of the Almighty. I read his book and it says he cares not for the unsightly.
Okay, we are back. Randy Kelton, Rule of Law Radio. And we're talking to Joseph in New York, and we have spent an hour, but this is a great subject. this is the place where we're beginning to make great headway in taking back this country from our overzealous public officials. Okay, so this is a tactic for going after public officials with the grand jury. Now, there's one facet of this. You were denied due process, and that can be charged in the state or in the Fed. And the kind of rule of thumb is go after the Fed in the state and the state in the Fed. I'm about to file criminal charges against a federal district judge with a state grand jury because he committed a crime from the bench, and the federal courthouse is not a federal enclave. So, like if the judge pulls out a pistol and shoots an attorney, he's prosecuted in the state, not in the Fed, because the state has jurisdiction. So if you're in the state, you want a shot at the Fed. So due process gives you a shot at the Fed. This is all about politics. It's about getting people breathing down their necks. So you make up a complaint about the due process denial, and you file that with the federal grand jury. Now, what's going to happen is if the U.S. attorney is going to intercept it and use that same cover letter and run the same routine on the U.S. attorney. When you don't get the letter back from the foreman, or you get a call from the U.S. attorney, he's likely to call you and say, "What the heck is this?" And you're going to say, "Who the heck are you? Why are you talking to me? You're not the grand jury foreman." And he's going to say, "Well, we received this. How did you receive it? It was sent through the mail to the foreman of the grand jury. What in the heck are you doing with that?" They're not used to dealing with their masters. So then you send a complaint the same way against the U.S. attorney. And you hope that you get intercepted by the FBI. You hope they send out FBI agents to talk to you. That's what they did that to me once in the past, but only once. They don't do that anymore. That did not work out so good for them, because what the FBI agents will do is try to intimidate you, and you hope that they tell you that trying to contact the grand jury foreman is jury tampering. Oh, is that a fact? And threatening me is witness tampering. Let's see how that works out for you, Bubba. Then you file against the agents and the U.S. attorney for conspiring with one another to tamper with the witness. It makes sense. Well, you've obviously listened before, and you're obviously knowledgeable, so you kind of understand how the routine works.
Yes.
Okay, so we just start running it up the flagpole and get these guys jumping up and down. And there's some lowly municipal judge down there in the bottom who's got all of these high-level officials really PO'd at him because he sicked you on them. It's all about the politics. When I took my complaints in, I went to see the district attorney, and I said, "Greg, instead of me going and approaching the bailiff, will you agree to just give these to the grand jury?" He said, "Yes, Mr. Kelton, I'll do that." And I said, "Well, thank you for protecting me from the bailiff." He said, "Mr. Kelton, I was not protecting you from the bailiff. I was protecting the bailiff from you." Oh, okay. And he didn't want the bailiff doing anything stupid and then get me to go after him, because he certainly knew I would.
Yeah.
You want these guys to think that Joseph comes down here and his only purpose is to try to get us to do something so he can run down and file criminal charges against us. And they're right. That's exactly why we should be there. And that's why I say never ask a public official to do anything you actually want him to do. Because you never ask him to do anything that the law does not specifically require him to do, and then don't give him legal advice. It's all about bushwhack. And in these circumstances, bushwhack is perfectly acceptable. If you try to give them legal advice and fair warning, they'll consider that a threat. So they get no fair warning.
No.
They are expected to know the law. If they don't know the law, they're screwed. Screws v. U.S. A private citizen may not claim ignorance of the law as a defense to prosecution. A public official is held to a much higher standard. If a public official violates a ruling of this court and he be sane, he may not be heard to say he knows not what he does. Mm-hmm. So you and I, we must go into the court and approach our public officials from the perspective that they know exactly what they're doing. If they're not insane, then they know exactly what they're doing. And if they do something wrong, it's inappropriate for me to tell them they already know. So I'm not going to tell them what they already know.
It doesn't work out so good.
It never works out if you try to be reasonable with these guys.
No, they instantly use it against you in ways you can't imagine.
Right, you can't be civil.
No.
Civility, civil. Actually, when I say civil, I mean civility. You can't exercise civility. Civil, when used in court, refers to a claim under a tort or cause of action. Criminal applies to a claim under a statutory violation. But when I say you can't act civil, then that goes to civility. And if you try to be civil with these guys, they'll use it against you every time. So we're the master. I invoke your duty, and I just told a sheriff's deputy this the other day. He said, well, maybe the reason you're having all these problems, Mr. Kelkin, is you're rude. I said, well, possibly. But here's how it works, Bubba. You're the servant, I'm the master. I invoke your duty, you do your duty. Like it, not relevant. He hung up on me. Oh, that was wonderful. That was so much fun to say to him. Anyway, that is the problem we have with this. It gets to be way too much fun.
Yeah, I sometimes I think I get myself into more trouble because I enjoy myself too much.
I'm hoping other people understand this. Joseph, do you find that when you start taking them on, that they tend to retaliate against you?
It depends. The real smart judges do the opposite.
And this is what people need to understand. Judges on the bottom. If you've got a municipal court judge, he's a lawyer, most of them are, he's not the sharpest knife in the drawer. If he was, he'd be making the big bucks. He wouldn't be down here working on his off time, being a municipal judge in a podunk city. So he doesn't start out to be the sharpest knife in the drawer, so don't expect too much from him. But as you move up the ladder, you get into judges who are professionals at what they're doing. They're elected into office, so they're very sensitive to public opinion. You will find they are far more civil, far more careful, and a lot smarter. When you come in and you pose a political threat, they recognize it very quickly. And when you come in deliberately setting them up, they recognize that very quickly as well. And they get really careful, really fast. You become Mr. Joseph, sir, really quick. And if you could ever get a bailiff to give you a hard time after you stung the judge, like I just stung the district judge. If I go to that courthouse and a bailiff gives me any problem, I'm going to accuse the district judge of sending this bailiff to retaliate against me. Oh, you talk about getting excited. I accused a deputy once who told me I couldn't have an open flame because we have a fire ban on. He was a new deputy. He didn't know who I was. I live right next to City Hall. And I said, you're kidding me, right? Oh, no, sir, you can't have that open flame. Wait a minute. That district judge, John Fostel, sent you down here to harass me, didn't he? Just because I filed one crummy little complaint against him with the attorney general, he sent you down here, didn't he? And this cop stepped back, held up both hands with his palms out. One moment, sir. Takes out his cell phone, dials. In about 30 seconds, Tom, the chief of police, stepped out of City Hall, looked over at us. Randy, what are you doing to my new officer? Oh, Tom, I was just jerking his chain. And the cop said, oh, God, I saw my whole career flash before my eyes. Because if one of these guys give you a hard time and you accuse the judge of doing it, perception is everything. Doesn't matter if he did it or not. It's going to stick to him. And that judge, the best thing to accuse them of is something of which they are totally innocent. because the judge, if he's innocent, will go ballistic. And you can apologize. This is way too much fun.
That one. Never tried that.
You will find, that's people tend to be afraid that the police will retaliate against you. You get them on that one time, that'll end that stuff. The word will get out. Leave that no good scoundrel alone. 4 years later, I got pulled over one morning by a sheriff's deputy for doing 70 and a 60, pulling a big flatbed trailer with no plates on it. And he come back and gave me a warning, told me to slow down and get those plates fixed. The next day I walked in the convenience store across the street, and Bobby Jack Cruz is in there, and he always listens to his police scanner. What'd you do to that sheriff's deputy yesterday? Why didn't you do anything to him? Why? Well, he called in your name and said you were doing 70 and you didn't have plates on that trailer. And the dispatcher said, don't you dare give that SOB no ticket. You get him out of there. If we can get a couple of guys in every county like you, Joseph, we'll change everything. Hang on, about to go to break. We'll try to finish this up on the other side. We have a bunch of callers. We want to get to everybody. But hang on, Joe. We'll be right back.
This is the Logos Radio Network.
Ain't gonna blind me.
Okay, we are back. Randy Kelton, Real Law Radio. We're talking to Joseph in New York. Joseph, we've kind of worked over that subject, which is one of my favorite subjects of all. Is there anything else you need to ask that I haven't addressed?
And that pertaining to what we talked about today. So last time I called in, we talked about property taxes, and you mentioned a fellow in New York State who had learned how to acquire, the proper process for.
Yes. He happens to be in jail now, but that's because he pulled some stupid stuff with a pistol. Had nothing to do with this process. What he does is he sends a letter to the tax assessor collector and asks the tax assessor collector if the state has any claim against his property. And if your taxes are all paid up and everything, he's going to say, you're going to get a letter back saying no. Then he sends another letter to the assessor asking him to place your property on the private rolls. And once they move it to the private rolls, you don't get taxed.
Yes. I believe we had we were talking about having a contract with the fire department, the police department, and in New York State, that's not the case. I believe the argument that was used had to do with the fact that on a farmer is allowed to take up to 110 acres and put it on the private rolls. He's only taxed up.
Okay, wait. Let me clarify. When I talked about getting outside the contract with the fire department and the police, that went to a land patent. And this is not going to either an alloidal title or a land patent. It's just moving in, and it doesn't rescind the title. It leaves the title in the record. It just moves you to the private rolls. Now, this was in New York, so I know that does it in New York. And I don't know if other states are similar because this guy never came across with the statutory support for what he was doing. So I couldn't analyze it as to exactly how he was doing it. But this was a little bit different than the alloidal or land patent title.
Yes. Okay. Well, okay. We went over that, and I did take notes on that. So for now, I'm pretty good. I really think I should get off the air and give these other folks a chance to, get some help from you. And Jesus, it's been wonderful. You really helped me a lot.
Good, and, wonderful. Don't be a stranger. You are the reason I do this show. I need other people out doing what I'm doing, and it's contagious. Once you realize that the scam they've been playing against you to try to keep you afraid of them, once you look behind the curtain, everything changes. So the more people I can infect with it, the more people I'll have like you out there infecting other people with it, and we can get control of our system back without having to completely revamp the system. We've got all the tools we need. We just need people using them.
Yeah, exactly. All the laws we need are there. And I have had some successes. I have taught some people things, and they've prevailed. And it's really surprising. You can never predict who's going to take it up. You know, I've had people come to me that I thought were just the most lazy, shiftless people in the world, and boy, they ate it up and really kicked butt when they went to court. So you just never know.
Yeah, we just got to keep putting it out there. Okay, Thank you very much, Joseph, and keep us up to speed on how this works out for you.
Will do.
Okay, thank you, Joseph. Now we're going to go to Scott in Texas, and Scott is another one that's pretty much doing what Joseph's doing. Hello. Okay, there you go. Hello, Scott.
Hello, Randy. How are you?
I am good. Okay, I understand you're getting ready to go to trial in Addison, Texas.
Well, actually, it's going to be a motions hearing on discovery for the police video of them when they smashed out my window.
Wait a minute. Has your challenge to subject matter jurisdiction been heard?
No, I believe not. In fact, It was supposed to be that one, and then when I submitted for discovery, then they kicked it back, and then they said this is going to be for discovery. And I was
they can't hold discovery until the court has proved up. They can't hold a motion of any kind until the court has proved up jurisdiction.
Well, they obviously are running on they have jurisdiction. So because I've submitted,
no, you have a motion before the court, and you have a right to a ruling on that motion. Until there's a ruling, they don't have subject matter jurisdiction.
So do I have to go in there and say I need to? Well, first off, I was going to go in there and challenge subject matter jurisdiction anyway, and there is a motion that should be in there that hasn't been heard.
Here's how you do this, Your Honor. I am here at arm's length to the court. The court must prove subject matter jurisdiction before it can move ahead with any other actions in the case. So prove it up. And he may say, well, this was a discovery hearing. This can't be a discovery hearing because you haven't proven jurisdiction. I have challenged it. My challenge eliminated your subject matter jurisdiction until it's proven. If you attempt to perform any act in this case other than proving up subject matter jurisdiction, you'll be acting beyond scope. And if he is, in fact, a lawyer, he'll know exactly what that means. It means I get to sue you personally, Bubba.
Yeah, he is a lawyer because I bar grieved him.
Okay, so when you tell him you're here at arm's length to the court and demand that he prove up subject matter jurisdiction, not the opposing counsel. Opposing counsel doesn't have to prove up jurisdiction. Now, the opposing counsel can do that, but he's not the one responsible for proving jurisdiction. It's the judge who has to prove jurisdiction. This issue's between you and the judge. He don't prove it and acts as if he has it. Now you get to sue him personally. So don't let him snooker you around. I once had a judge in a case. I was just talking to someone about this the other day. He went in and he had a demand for jury trial, and the judge asked him a couple questions. And the guy was pretty fiery, and he got him talking and responding and answering the questions, and went on, and they threw his case out. There was a friend of mine was against him, and I was trying to help him out. We get outside, and Bill said to his lawyer, I thought he asked for a jury trial. And the lawyer said, yeah, he did, but the judge screwed him like a tied goat. So the judge will screw you like a tied goat if he can. So don't let him.
Agreed. Well, let's just say he whips out the motion and denies that, and then I'll go ahead and say, well, what about the discovery? And then he'll probably just deny that. And, he's going to deny everything. I'm going to ask him to recuse himself, deny that. And
No, wait. They can't get there. I suggest that when the judge, if the judge doesn't hold a hearing on the challenge to subject matter jurisdiction, you walk from the court. You know what he's going to do with you. Others, anyway, you're challenging subject matter jurisdiction. And when he bypasses it, you can't. You let the court know we can't go anywhere. We're done here, and leave. That'll tense them up. Then they know you understand, and you're not going to be led into bypassing the issue of jurisdiction. We don't go anywhere until you get over this hurdle. And if they hold a hearing and rule that they have jurisdiction, that's okay. Then you go on to the discovery. Hang on, about to go to break. But okay, you force him to hold the hearing, and then the lawyer on the other side screws up his argument, and then on appeal you get the clobbering good. Hey, Randy Kelton, Vet Pack, Rule of Law Radio. We'll be right back.
Get out a hat and sunglasses. In San Diego, law enforcement agents are using video surveillance cameras and facial recognition to pick faces out of crowds. I'm Dr. Catherine Albrecht, back with details in a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Privacy-invading technologies are coming online faster than you can scream Big Brother, and one California company called Face First tops my spooky list. Face First has developed scanners that can sweep a crowd from 100 feet away to record every face and feed those images into a database. People are identified in under a second. Already deployed in Panama, Face First is now being tested on San Diego streets. Imagine the feds, drones, marketers, and stalkers all scanning our faces and identifying us as we walk down the street. Yikes, I'm buying a floppy hat and some sunglasses. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
We'll be kidding about chemtrails.
Looking for some truth? You found it. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Scott in Texas. Okay, Scott. We were talking about posture. So, what do you think? Does what I said make sense?
Yeah, no, that makes good sense. The only reason I was going to ask for the judge to re-recuse is because I filed criminal complaints on the judge, and I had to take them to the actual sergeant of that courthouse of the police station, and he refused to take them. So now I filed a criminal complaint against the sergeant for failure to report a felony and obstruction to the judge. So the judge already has that stuff sitting on his desk that he has a criminal complaint against his sergeant because the sergeant wouldn't take the criminal complaint against him. So
you're enjoying this way too much. That's perfect.
That's why I was going to say he needs to recuse himself. So,
Okay. This is about the point, the keeping track of exactly where we are. It's inappropriate to ask him to recuse himself because he hasn't established that he is a proper judge in the case. So you stand on the subject matter jurisdiction challenge, and as soon as he makes a decision on that, then you move to recuse.
That's where I was going.
Oh, okay.
The first thing was I was going to say I want this whole case dismissed, and naturally he's going to say no. And first challenge subject matter jurisdiction. Say
Okay. Hang on. You can't ask him to dismiss the case because he has no subject matter jurisdiction. He can't make a determination.
Oh.
I'm sorry. You're right. He can dismiss. There's two things he can do. Without subject matter jurisdiction, he can't make any kind of ruling concerning the adjudication of the case other than to dismiss for lack of subject matter jurisdiction.
Bingo.
That's all he can do, and you're right. You can ask him to dismiss the case. And then you're not invoking his jurisdiction by asking him to do that. You're not asking him to exercise any discretion because you're claiming he doesn't have any. Anything else then goes straight to recusal. That ought to tense him up good. He recognizes it when you're walking right down the code with him. He's a lawyer. He knows he's going to try to pretend like You don't know what you're doing. We don't care what he pretends. This is good. You and Joe are doing good.
Well, you're my mentor. So that's okay. I got plenty of other things going too. I got plenty of irons in the fire. So we'll just leave it with that for this evening because let some other callers get on. So anyhow, I will give you a holler Monday or something.
Okay. Thank you, Scott. Okay. Now we're going to go to Jacob in Texas. Hello, Jacob.
Hello.
Hello. What do you have for us today?
Hey, Randy. So I barely got in touch.
Hold on. We're getting some serious distortion here. Can you move the mic just down by your chin, just out from in front of your mouth?
Is that better?
That's better.
Okay. Yeah, so it's where I am. So I recently got a traffic ticket, and I'm pretty new to this.
Okay, I am sorry, Jacob. We're having some serious technical difficulties here. Are you on something like a satellite internet? You seem to be getting latency.
Regular cell phone. Hold on 1 second.
Then you might hang up and try calling back in. What we're getting is the second half of your words. We're losing the first half.
Is that better?
That sounds a little better, yes.
Okay, yeah, I had my Wi-Fi on my phone, so that's probably what it was. But,
okay, good. That's better.
So I recently got a traffic ticket, and I'm just recently got on to you guys doing the law radio. And I was really kind of flying blind in this. I got a couple of like notions of ways to go about it, but the first thing I wanted to ask you, so I have a ticket in front of me, and right off the bat, obviously it's under the transportation code, and I was just traveling. It's for an expired registration, which, I mean, I don't believe I should have to register my vehicle for personal usage. Even right off of that, even before that, on the ticket itself, there's a violation time, which was well before the time of when I was pulled over, because at the time stamped on the ticket itself, I hadn't even left my house at the time. So immediately, isn't that the government record that's in there?
Okay, hold on. On a complaint, there is one thing that is sudden death.
Mm-hmm.
If you file the complaint before the actual crime was committed. So he has a time on here that's before the crime was actually committed.
Well, let's put crime in quotes, but yeah.
Yeah. So you can claim that this is sudden death. This is not something that can be repaired. Other minor errors on a citation can be repaired. But the wrong time and date on it can't be fixed. He's accusing you of committing a crime when you hadn't even left your house yet. And you claim that can't be fixed. This has to be dismissed. Now, he can refile the citation with the correct time on it. But odds are he won't. Anyway, go ahead. That's one argument you can make.
Okay. And so then the actual appearance is not for another more week or so.
Wait a minute. I'm still getting horrible distortion.
That might have just... Is that better?
Yeah, move the mic away from your mouth. What it sounds like is happening is you're overpowering the mic, and when you do that, it shuts off until the level comes back down where it can operate. So it shuts off the first half of the word. So just back it away from your mouth a little bit. Try that.
Okay. So I have a couple more weeks before I have to appear, and obviously they want a pleading of guilty or not guilty or no contest. And I'm still under the impression that I didn't actually break any law, but even if I pled not guilty, I'd be kind of saying I'm not guilty of this crime that I didn't even commit, though. So really my question, I guess, would be, how would I go about this? It's just file a motion for, I guess, what is...
Okay, hold on. What was this charged in a municipality or a county by sheriff's deputy?
It was by an APD officer in Austin, Texas, under municipal system.
Okay, so it's a municipal entity. Okay. How big? Okay, there's a limitations on how big is the municipality. What city is it?
Austin.
Austin. Okay.
Yeah.
You need to send me an email, and I'll send you a document I made up for Scott that was on just before you for Addison, Texas.
Okay.
But in that challenge to subject matter jurisdiction, I list all of the statutory conditions that must be met in order for an officer to be able to enforce the traffic code or the transportation code.
Okay.
And then you can compare that to Austin. I don't think Austin meets the requirements.
Okay.
Okay. Hang on. About to go to break. Randy Kelton, Vet Pack, Rule of Law Radio. We'll be right back.
Easy.
Well, you know, karma is lurking around the corner. You better watch every step you take. And good will follow you. Yeah, Billy Jerry, sing reality. Okay, karma is lurking around the corner.
Okay, we are back. Randy Kelton, Vet Pack, Rule of Law Radio. And we're talking to Jacob in Texas. Okay, Jacob.
Okay, so you just want me to send you an email bill at Randy.
Wait, you need to move the mic away. I'm having terrible time understanding.
It's bad reception in my area, so mine would be my microphone placement. Well, since we just have a bad signal, I can hopefully...
Wait a minute, Jacob. The sound is worse than before. We can't understand you. You might try hanging up and calling back from a different location.
Yeah. I'll just send you an email. Hopefully that'll get through.
Okay.
Try
it from a different location. Maybe we'll be able to hear you. I'll bump you up to the top when you call back in.
Yeah, okay.
Okay, thank you, Jacob. Okay, now we're going to go to Mark in Louisiana. Hello, Mark.
Hello, Randy. How are you tonight?
I am good. What do you have for us today?
Well, can you hear me okay?
Yes, I can.
Good. I had a little issue concerning mortgages and escrow. 2 years ago, my wife and I bought this house, about $50,000, and we made sure we had fixed rate, so they couldn't jack with that. No balloon payments at the end, so they couldn't play with us there. So what they've been doing is they've been, every so often, they'll say that our escrow is shortage, so they've got to bump our payments up to meet the shortfall. And it's going from like a little over $400 a month up to the newest payment's going to be like $572.
Okay. Have you filed a qualified written request?
No, I haven't. This is, this last deal we got, it had been going for a while, pretty steady, and all of a sudden we got this last one here last week, and I thought I'd call in and maybe get some options. I've listened to some of the archives and stuff, and I got a rough idea of how you work things, but I want to get some options, to see what I can do with this.
Okay. You have a note, and on that note, you agreed to pay a specified principal at a fixed interest rate. And that specified principal at a fixed interest rate over a given period calculates to an amount that is indicated on your note. Now, you need to get a complete accounting of all the payments. And then you want an escrow accounting of all of the amounts paid by the escrow company and all of the documentation in terms of billing and invoicing in support of those escrow payments. You are in Louisiana. I'm not sure about where the law is in Louisiana. Louisiana is different than all the other states in that Louisiana is based on French law. So I'm not sure if you have pre-litigation discovery. Look up pre-litigation discovery in Louisiana. Okay, most of the states have this in one form or another. And in all but Texas allows relatively extensive pre-litigation discovery. Most of the other states reflect the federal pre-litigation discovery statute, and it allows you to do depositions. So you want to look at deposing the escrow agent. You want him to come to a deposition, bringing a complete validation of every debt assigned to this mortgage, so that you can depose him and do a proper accounting of the mortgage. That will get these guys hopping up and down, because escrow is probably one of the most fertile fields for fraud.
Yeah, they claim that our insurance, and in truth, the insurance has gone up some, but when they say there's like a $600 and some odd dollar shortage, and here just I guess it's sometime last year they was claiming over $400.
Okay, hold on. What kind of insurance are we talking about here?
Well, see, it's all the homeowners insurance. I think that includes the flood and all that.
Okay, homeowners insurance as opposed to mortgage insurance.
Well, we have that too, which I'm not really sure about. That doesn't.
Okay. If you're paying for it, you want to see the policies. Do you have the homeowners insurance policy?
Yeah, well, I think we got that. My wife's got all the paperwork on that. I think it goes to USAA.
Okay. You need to see the policy, and if it goes to USAA, send USAA an accounting. Now, USAA, as insurance companies go, is one of the better ones. Ask them for a complete accounting of everything that's been charged toward this particular property. And then compare that to what your servicer is claiming you owe. If it don't match, now you have reasonable probable cause to make a claim against them. So you send them a tort letter or a qualified written request. A qualified written request is a document claiming an accounting error and a request that they correct the error. Now, if your servicer hasn't changed within 30 days, you can't file the lender is not obligated under the Real Estate Settlement Procedures Act. But under normal contract law, he is still obligated to give you an accounting. If he fails to give you accounting, that creates reasonable probable cause that you're being defrauded and gives you grounds to take action against him, in which case, if he doesn't respond, then you send him a tort letter claiming that all these excess fees are fraudulent and they are to tender all of those excess fees back to you.
And these fees, those are the ones you're talking about that you find on your HUD-1 settlement statement, all the for your closing fees, or you talking about the fees involved in the escrow?
Now, here where you were specifically talking about the changes in the amounts they're charging.
Okay, those are the fees I thought you were talking about. Okay.
So you want to add, you want validation of the amounts that are being charged. You want to see invoices,
right?
And I almost guarantee you they're not going to have invoices.
Oh, I would be willing to bet you too.
Yeah, if they don't provide the invoices, then you send them a notice of tort that you have overcharged me in this amount, and you need to run an accounting. You run a amortization. You can go online and download an amortization that is in spreadsheet format that will show you every payment and how much is it principal and interest for every payment. So you put into that the original amounts that you agreed to pay. And it'll calculate an amount that you owe. And then you go down, and everywhere they've charged you more, you put that in. You put what they actually charged you. And you keep a running total. What this will do is say on the second payment they charged you $5 too much. That $5 should have came directly off the principal. But it didn't because they charged it to you. So next month you paid interest on that $5.
Right.
Generally, across what's early in the note, across the full term of a 30-year note, it will increase about 3 to 4 times, depending on the interest rate. So if they charge you $5 extra on the first day, then that's going to be $15 extra they're charging you by the time you get to the end. So you run a calculation. If they charge you $5 extra on the first day, That's the last $5 you pay off on the whole loan. So you're going to pay extra interest on $5 for 30 years.
Right.
You run that amortization that way, and that puppy really adds up.
See, one of the things we do that really, I know it ticks them off, is every month when we make that payment, my wife will pay a little extra to put on the principal. And but we've noticed, and once we found out they were playing with the escrow deal, she started paying some extra to go towards the escrow.
Okay, hold on. Is escrow included in the contract? Did you agree in the note that all of the escrow would be paid by the lender rather than you?
I can't remember. I'll have to go through the paperwork and
check the note. Read the note, because they may have just decided to pay the escrow because that way they can cheat you. If you take your homeowner's insurance out of the escrow and pay it yourself, you don't have these problems. Okay, hang on. About to go to break. Randy Kelton, Vet Pack, Roosevelt Radio. I'm a little ahead of myself. I got another 28 seconds. I misread the clock. Okay, so we want to do an accurate calculation. And the first thing to ask them for is a complete accounting of everything that's been paid. Okay, hang on. We'll be right back. Roosevelt Radio, our call-in number 512-646-1984.